Good afternoon, everyone. I know we still have some people coming in the last minute here. I'll give it another second or two for people to come in. For those of you who do not know me, my name is Jordan Inver. I work at Stark and Stark in the Estates and Trust Group here. And I will be talking today about estate planning. Just a heads up, if anybody has any questions at any time, we do have the chat feature open. So, if anybody has any questions at any time, I'll be monitoring the chat. I also have my other individuals here who will also be monitoring the chat as well. And we can kind of go from there. So, as I said, I'll be talking about estate planning today. More specifically, I'll be talking about the difference between a will and a revocable trust. A lot of times we get people who say they need a will, and sometimes they don't realize that there are other factors involved in that, including uh, power of attorneys, trust, other documents. And the more common documents that we draft up from time to time are wills and revocable trusts. So I'm going to spend a little bit of time going into that. And like I said, my contact information is here. So if you have any questions or definitely want to reach out and connect, my contact information is there. So let's get started. As I said, I'm just going to start off doing a little bit of basics about estate planning. So, why does this matter for more particularly Pennsylvania and New Jersey residents? So, there are certain factors that play specifically with when you're talking about estate planning. More specifically, there are probate rules and inheritance taxes that are both present in both Pennsylvania and New Jersey, but their slightly concepts are slightly different in both states, and as a result, that can definitely affect the costs that are associated with managing an estate and the administration that's involved there. Um, and then, I think what this is focused on, what this presentation is focused on today, is just really understanding the differences between wills and revocable trusts. And if I can simplify it down to its basic level, um, it really comes down to two fundamental differences between the two. So, on one hand, a will requires probate, which is basically the process of making a will effective after somebody has passed away. And it's public information for the most part, versus a revocable trust where it kind of offers privacy and avoids court involvement that would be involved in, let's say, probating a will, but with the caveat that it's funded properly. And I'll kind of go through the basics in a little bit, talking about the different types of considerations that are involved with revocable trust. And then ultimately, it comes down to how your beneficiaries will be impacted. You know, there's incapacity planning and can and how determining how quickly assets are transferred that really factor into deciding, do I need a revocable trust? And I'll get into that a little bit later in the presentation. So, what is a will? I know a lot of people think of a will, they think of, just a document, but it does way more than just lay out your plan. Um, a will directs how a person's assets are distributed after death and takes effect only upon death. So I emphasize the words after death and takes effect only upon death, as I will explain later on. Um, in a revocable trust, assets are kind of handled while the grantor is still alive, and it takes effect immediately upon signature. So, unlike a will, which, and I'll just kind of sidetrack for a second here, that once somebody passes away, the number one question I get is, how does the process start? So usually what will happen is whoever the executor is, and I'll mention and I'll talk about the defining terms later. Whoever the executor is, that's the person in charge of the will. They will take the original will, they'll take a death certificate, and they'll bring it down to the county in which the surrogate's office of the county in which the decedent resided. And they will say, I'm here to start the probating process, and usually it's kind of done from there, and it's usually a lot of hand holding that goes through that process. But yes, as I mentioned, as I just pointed out, there is a probate process. Probate kind of validates the will through court supervision, and whoever is appointed as executor in the will, that's kind of their time to shine per se, where they kind of take on more of a role in managing the estate and running through the day-to-day operations of managing the estate. Just some of the responsibilities that the executor will have. Usually they're in charge of gathering assets, paying any obligations, debt, or taxes out of the estate account. One of the requirements is that they'll be to create a bank state account so that monies can be tracked and everything like that. And then ultimately, after all the steps are completed, their job is to ultimately make sure that the assets are properly distributed according to the will's instructions. And usually that comes in the form of issuing what are called refunding bonds, release and refunding bonds. And what that basically does is that discharges the executor from their job, from their role, and it also kind of puts a figure onto how much each beneficiary is getting. So that's kind of the last step that's done before distribution happens. Um, while they are very helpful, there are a little bit of intricacies that are worth mentioning. More specifically, in most states, wills are public records and can be accessed by the public, which if you're very much into the privacy component, it's not very keen per se. Um, there can't be incapacity planning because the wills don't take effect until the individual has passed away. So there's really nothing that can be done to plan for, okay, maybe the person is not deceased, but he can't manage his own funds or handle any type of funds or day-to-day decision making there. So there's no incapacity planning that can be involved there. And as I mentioned before, as you've heard me say a lot during this 10 minutes so far that we've been here, it requires probate, which is a lengthy process and can potentially cause delays and certain costs involved. So yeah. Now, on the other hand, what is a revocable trust? Now, I will say, I've tried to distinguish between revocable trust and wills. Being said here that revocable trust, for the most part, we usually have a will component with it, but what it basically is, it's a pour over will. It's not really a substantive will that kind of differentiates itself from the will that I talked about previously, but it's a pour over will that basically the will just states that all the assets are going to go into the trust. As I mentioned previously, revocable trust does allow for incapacity planning. So it allows for, any type of changes or amendments that can happen anytime during the grantor's life for flexible control. I shouldn't just go back real quickly and say that that's also the same case in a will for the most part. You can, if situation changes where you're not able to, where maybe you don't get along with a beneficiary, maybe you need to add a beneficiary, you can still do that with a will. But you could also do it in the revocable trust as well. one of the big advantages with the revocable trust is the avoidance of probate. Properly funded trusts, they bypass probate, ensuring that there's the direct transfer of assets to beneficiaries. And it's a very more direct process otherwise than what would happen through a probating a will. As I had mentioned previously and emphasized, revocable trusts allow you to name trustees and successor trustees in the event of incapacitation or death. So if you are an individual that, let's say, you want to name mom as backup trustee, and then in the event that mom passes away, you want to name dad as second backup trustee, you can definitely do that. Um, the main job that trustees have in a revocable trust is that making sure they're in charge of managing the trust assets. As I mentioned previously, there's no court involvement, so usually it really ensures a smooth continuity and making sure that assets are handled correctly. And it's a very broad document if you decide to go the revocable trust route, but it does handle and take care of a lot of situations and a lot of different details that go into it. Um, but I guess the one downside with a revocable trust is it can be costlier up front. Um, especially if you're doing a revocable trust, it can be costlier and it can be more complex. So sometimes that does require more time up front, understanding the document and everything like that. But it ultimately will reduce time and potential expenses later on. So those are the considerations that kind of go involved there. Funding a revocable trust. So you might ask yourself, okay, Jordan, a revocable trust is great, but how do I go about funding a revocable trust? Well, there's many different um, assets that are involved, and I'll go through each one now. So the first type of assets that you would consider putting into the revocable trust is bank accounts. My only suggestion there is I would contact whatever bank you have to make sure that you are retitling your checking, savings, and money market accounts to the trust. Um, and then I would just make sure that if you aren't going to retitle the bank account into the trust, and let's say you want to add a beneficiary designation to your bank account, sometimes we also see is that the trust are named as beneficiary designation as beneficiaries. So I'm just going to use me for example. Sometimes if there's a bank account and there needs to be a beneficiary designation on it for let's say a Santander bank account, the beneficiary would be the Jordan R. Inver Revocable Trust. And in that event, upon my death, for example, it would just go right into the revocable trust. Brokerage and investment accounts. Those are another type of assets that are involved. Usually, banks or different financial institutions will have transfer forms that need to be filled out. My suggestion is just fill them out to the best of your ability. If you come to us and you have a revocable trust that you need help funding, um, we can definitely walk you through those forms and help you fill those out. Real estate. Real estate is one of the biggest questions or one of the biggest issues that we sometimes see when it comes to funding a revocable trust. So usually what we recommend is that there will need to be a preparation and recording of a new deed transferring the property to the trust. Now, if you have a mortgage on the property, that's kind of another wrinkle that can be added into that because then, specifically in New Jersey, you'll be subject to a transfer tax fee. So that consideration is based on the amount of the outstanding mortgage balance if there is a mortgage on the property. And I know there's different calculators that you can go to online and enter in, if you have a certain balance remaining, what that is due. And you can enter in a bunch of calculations and it'll work like that. Um, Pennsylvania, on the other hand, they do not have a transfer tax fee. However, I recommend this to anybody who's considering putting a house in trust. If they do have a mortgage on the property, contact the mortgage lender or contact the mortgager, whoever that is, because sometimes what will happen is the mortgage company will say, "Yeah, this is totally fine. You're allowed to do this. However, we want to refinance your mortgage." And once you get to refinancing, sometimes individuals don't want to do that. So, my only suggestion is to contact your mortgage company and just confirm the details and make sure that's okay. That's kind of getting to verifying the local recording requirements, making sure that's there. And then last but not least, just making sure that the homeowner's insurance is updated to reflect the trust ownership properly. Um, that there. Life insurance and retirement accounts. This is another common question that I get sometimes from individuals about how or if they should put their life insurance or retirement accounts in the trust. And the answer to that question is a big fat no. Do not retitle these accounts. I will say that and repeat that again because sometimes people get confused. Do not retitle these accounts. Kind of similarly to what I suggested with bank accounts, if you don't decide to create a bank account for the revocable trust, update the beneficiary designations to name the trust instead as a beneficiary of the life insurance and retirement accounts. I should just stop for a second and also say that, if anybody has any questions or wants or needs access to these slides, I will be more than happy to provide them. You've seen my contact information at the beginning. My contact information will also be at the end too. So I can also supply these at any time afterwards. Business interest. Usually 9 times out of 10, when we're dealing with business interest, the main thing that we ask for are if there are any current operating agreements or stock certificates. And my only recommendation there is that if you're going to include business interest in a revocable trust, is that the operating agreements or the certificates are amended to reflect that trust ownership. And usually sometimes that might involve obtaining consent from other owners if you're not a primary owner. Vehicles. Usually, for the most part, this is not as common. Um, I just will say off of personal experience, have never been asked, "Hey, Jordan, I want to put my vehicle in a revocable trust." Um, but my only suggestion there is to check your state DMV rules. And if insurance policies need to be updated, to definitely go that route. But it's not as common as you would think with having vehicles be in a revocable trust. So I add that in here, but again, not as common as people may think. Personal property. So what we most commonly suggest is that, and we have the document. It's what's called a memorandum of personal property. And what it does is it divides the document up into two columns, the personal property on one side and the name of the individual on the other. And so, for example, if I have a watch that I want to give to a cousin or grandchild or something like that, this document allows me to put that information in there. And let me just say that can happen both in the will and in the revocable trust. Um, doesn't have to be done at the time of signing either document. It can be done at any time, but it's just a separate document that allows you, if you know you have specific items that you want to go to specific individuals, it allows you to have that flexibility and allows you to do that. Safety deposit box, some of these assets are not, maybe come up once in a while. If you have a safety deposit box, make sure you change the ownership or add trustee access to the safety deposit box. Digital assets, again, it's kind of not as common, but with technology and everything going on, sometimes we'll have digital assets that want to be added to a revocable trust. Just make sure, you're updating online accounts and passwords in the secure inventory. And usually if there are digital assets involved, there are a couple additional provisions that are involved with um, the revocable trust itself. And then, like with any of the assets that I've mentioned here, make sure you're keeping a record copy of all transfer documents. I even suggest maintaining a schedule listing all trust assets, and I would just have that document there, and I would review it annually for new assets. So if I know that there's a new asset that we're obtaining a new asset, I would just make sure, it's never wrong to properly record keep. So everything's sort of in line and everything's good there. Alrighty, so I know I said a lot of information, but this is just in because I'm a visual learner. I like to look at charts. This is just a chart with the basic breakdown. So as I mentioned previously, with a will, probate's required in both Pennsylvania and New Jersey. It's public record, it's effective at death, and there's no incapacity planning. Where on the other hand, a revocable trust, it avoids probate if funded properly. It is private, it's effective at signature, so effective during life and after death. And then there is the allowance for incapacity planning. And then, um, as I said here before, the initiation, usually you file the will with the surrogate's office. Um, and then oversight, it's usually court supervised for the most part. And it can take it can be a lengthy process. For trust administration, the trustee usually assumes control right away. Um, it's a private process, and the effect of the trust usually happens immediately. I kind of mentioned it earlier, but just to dive in a little bit more, talking about the differences in the roles of executors and trustees. So, as I said before, executors, their main job is making sure that the will's followed. They're in charge of administering the estate after death, paying any outstanding obligations, paying any debts, and making sure that assets are being distributed as followed per the will. Trustee, it's kind of the same sort of function in terms of the revocable trust, but they are more involved right away in that they manage the trust assets from the creation of the trust and make sure that there's ongoing administration being maintained of the revocable trust. And again, it's without court involvement. Fiduciary obligations both involve fiduciary obligations. So both executors and trustees, they will owe fiduciary duties to their beneficiaries, ensuring that there is responsible management, that nobody's stealing funds out of the trust or keeping assets for themselves that may need to go to a beneficiary. So there are fiduciary duties and obligations involved in that. And then kind of the main difference between the both of them is that executors will act, or their role kind of begins after death with a limited term, um, while trustees often have longer term management duties involved in that there. So now to kind of get a little bit away from revocable trust and wills and kind of talk more broadly about state specific and federal considerations. So there are two type of taxes that are usually most common when dealing with estate planning. You have estate tax and you have inheritance tax. So federal estate tax laws, they usually apply to larger estates for the most part. And the reason why is because in 2025, the exemption was, I believe, it was 14 million for individuals and around 28 million for couples. And anybody who's under that didn't have to worry about a federal estate tax. That number with the big beautiful bill has gone up. So for this year, uh, 15 million exemption for individuals and 30 million for couples. And like I said, if you're under that, then you really don't need to worry about a federal estate tax. The other tax that's most commonly involved is the inheritance tax. So again, New Jersey and Pennsylvania, they both impose inheritance taxes. And for the most part, it is based upon the beneficiary's relationship and asset values. Um, just to bring up a common example, so in Pennsylvania, if you're a direct beneficiary, so if you're like a direct lineage beneficiary, child, grandchild, anything like that, you're subject to a 4.5% um, inheritance tax if you're a Pennsylvania resident. That's different than in Jersey, where if you are in the direct lineage, you're a child, grandchild, anybody like that, there is no inheritance tax. So you're exempt from the inheritance tax. So those are just the small little differences between the two. There are differences in tax filing deadlines. So New Jersey usually requires taxes to and the tax return to be paid and filed within 8 months of death. Pennsylvania is within 9 months. And this is where I really come in and say it's really important that you work with an attorney who is knowledgeable and understanding in this area, because it can ultimately help minimize tax burdens and burdens of your loved ones or individuals that you want a smooth compliance with after you're gone, and making sure ultimately that estate plans are compliance with state and federal laws. So that's why I really emphasize that it's important that you work with someone who's knowledgeable in this area. I know I've kind of emphasized it earlier, but just to get back on the pros and cons of wills and revocable trust. So I think and if I haven't emphasized it enough, wills for the most part, they're fairly straightforward documents, and compared to revocable trust, they're more affordable, but they do require a probate process, which can cause delays in public record exposure and even potential later cost down the line. On the other hand, revocable trust, they avoid probate, they offer privacy, and they do have that incapacity planning feature that you're not able to do in drafting wills. And really, what it comes down to is determining what are your needs, what are your assets, and how you best want to manage them, and how you just what you want your estate plan to be. And ultimately, I feel like consulting a licensed estate attorney is the best way to go. Someone who's knowledgeable in the area and can answer any questions or anything like that you may have. So, lastly, I'll say the next steps that should be taken or should be involved here. Um, Assess your personal situation. Review if you don't have a list of your assets, gather a list of your assets. If you know certain individuals that you want to leave your assets to, just make a note of it. And if you have any personal goals that you have in mind, understand your estate planning needs. write those down because they're all vitally important to when you do meet with an estate attorney that they're clearly stated. Decide on what is important to you as far as legally. So, privacy, avoiding probate. If you, let's say you don't care as much about incapacity planning, because let's say your durable and healthcare power of attorneys kind of handle those for the most part. It really depends on what instrument you kind of choose and what fits best for you, again, based upon your assets and everything else involved. Consulting an attorney who's knowledgeable in this area, scheduling a meeting with an estate planning attorney to discuss the potential options, assets that are involved in choosing between a will, a revocable trust, or both. Like I said, in the caveat that with a revocable trust, there is a will component, but it's more of a pour over will than it is a more substantive will. Um, and then ultimately, your estate plan should ensure smooth administration. Proper planning will help minimize cost, avoiding legal issues, and ultimately protecting your loved one's interest. Um, and and just being able to manage those and ultimately make sure that your wishes are followed. So I believe that is the last slide. I just want to thank everybody for joining the presentation today. Um, if anybody has any questions, I don't see any questions currently in the chat right now. However, if anybody has any questions, here's my contact information. Please feel free to reach out. Um, if I'm not able to answer the question, I know my other colleagues who are in the Estates and Trust Department can answer them as well. But this is my contact information. I appreciate everybody for joining. Like I said, if anybody has any questions, they can contact me. And thank you guys for joining, and hope you guys have a good rest of your week. Thank you.